Welcome to the Law Offices of Chris M. Ingram podcast. Today we are starting a four-part series on the H-1B Visa Guide for Graduate Professionals. Part 1 of 4, Understanding the Opportunity. Before we get started, we would like to acknowledge attorney Chris Ingram and his dedicated legal team. They did a great job researching and preparing this material for us. We are thrilled to be able to present this topic for you today. Hello and welcome to the Deep Dive. We're kicking off a four-part series today that's really essential for any graduate professional thinking about building their career, their future, in the United States. We're diving deep into the H-1B visa, often seen as a critical pathway, but let's be honest, it's become increasingly complex and competitive. So in this first part, we're going to lay the groundwork, really understand the huge opportunity the U.S. presents, get a solid handle on what the H-1B visa actually is, and walk through that vital first step, the electronic registration.
That's right. For skilled professionals all over the world, the U.S. holds significant career potential. It really does. And the H-1B visa is pretty central to that whole picture. It's kind of the bridge, you could say, for talent to join American industries. Now, navigating it can feel, daunting. But having a clear understanding of the process is absolutely key. And the material provided by the legal team here, it offers a really valuable map for this journey. Gives us the insights we need to, break it all down. And while H-1B is our main focus today, it's useful to keep in mind there are other routes. The legal team points to things like the E-2 visa, which might be relevant depending on your specific situation. We'll touch on that briefly.
Okay, let's start broad then. Why? Why is the U.S. such a powerful magnet for graduate professionals from, everywhere? What's drawing them in? And, what's the sheer scale of this movement?
Well, the simple answer is opportunity. But it's opportunity on several levels, really, as the legal team highlights. The U.S. is genuinely seen as a beacon for global talent, especially in fields that are, right at the cutting edge. Think about sectors like advanced tech, biotech, finance, specialized research. A lot of the world's innovation is happening right here. Professionals want to be part of that. And beyond just the work itself, the financial rewards can be pretty significant. Competitive salaries, often much higher than in many other countries. And then there's the network. The ecosystems of companies, universities, professionals in certain U.S. cities, they create these sort of unparalleled career development chances.
Yeah, and we're not just talking generally, are we? The legal team's info points to specific geographic hubs, places where this talent concentrates and where these opportunities are really packed in.
Absolutely. These are the epicenters, really. We're talking about places like Silicon Valley in California, the tech powerhouse, obviously, New York City, global hub for finance, media, and increasingly tech, too. And Boston, definitely known for its biotech, healthcare, and all the academic institutions there. These areas just attract massive investment, foster innovation, so they naturally draw in the skilled professionals.
And when you look at the numbers, it really hammers home the scale of this. It's not a small thing. The legal team's data, drawing from sources like the Institute of International Education, it paints a really clear picture of just how many international students are already here, many of whom are, the pipeline for future H-1B candidates.
That data is quite striking, yeah. For the 2023-2024 academic year alone, over 1.1 million international students enrolled in U.S. colleges and universities. Over 1 million. And a very significant chunk of that number, 40%, were pursuing graduate degrees, master's or PhD programs. So you're looking at a massive pool of highly educated individuals already invested in studying here, getting exposure to the U.S. academic and potentially professional environment.
And it just makes sense, doesn't it? A large percentage of these graduate students are looking to, turn that U.S. education into a U.S. career after they finish. They've put in the time, the effort, the money. The natural next step is seeking jobs here.
Precisely. That transition from student to professional employment, it's a key path. And the H-1B visa is often the main way to make that happen. So when you look at those numbers, 40% of over 1.1 million students in grad programs, you see the sort of foundational size of the potential applicant pool right there inside the U.S. already.
Okay, let's drill down a bit then. Who are these graduate professionals? Where are they coming from typically, and what fields are they in? The legal team's analysis points to some pretty dominant trends here.
Yeah, the demographics are quite concentrated, and it's an important point. It reflects global educational strengths and migration patterns. Consistently, over 70% of H-1B beneficiaries come from India and China. The legal team suggests this is largely due to the, robust educational systems in those countries, producing huge numbers of graduates, especially in STEM fields, which are in super high demand in the U.S. But it's not just those two countries, of course. There are significant numbers also coming from places like South Korea, Canada, the UK, Nigeria, Mexico, Australia. It's diverse, but there's a clear weighting towards South and East Asia.
And their fields of study line up directly with those specialty occupations the H-1B is designed for, right? That makes sense.
Exactly. The legal team's findings show they're predominantly in disciplines like computer science, various engineering branches, data science, which is just exploding, obviously medicine, finance, and academic or industrial research. These are fields that just inherently require specialized knowledge, advanced degrees. To give you a feel for the volume, the legal team referenced data showing nearly 28,000 labor condition applications we'll get to. Those were filed just for software engineers in 2024. And over 278,000 for roles broadly in IT and math fields, often with high average salaries, especially in those key hub locations.
So beyond just, living and working in the U.S., what are the really specific drivers? What motivates these professionals, according to the legal team's insights?
Well, beyond the general appeal, the legal team points to very concrete things. Higher earnings are definitely a major factor. We mentioned competitive salaries, and the material gives some compelling examples, like the average salary for California tech roles at a company like Amazon being around $159,592. For many professionals, figures like that represent a huge financial step up. Another strong driver is the chance to collaborate with leaders in their fields, to contribute to really cutting-edge projects. Imagine working at Google or the Mayo Clinic. These places are at the forefront. They offer unique learning and impact opportunities.
So it's not just about the job title or the salary. It's about being part of something significant, working alongside top-tier talent.
Precisely. It's the chance to really accelerate their professional development and make a tangible contribution. And maybe the most compelling long-term motivation the legal team highlights is this. For many, the H-1B isn't just a temporary work visa. It's seen as a crucial stepping stone towards getting permanent residency, a green card. That offers stability, the possibility of a long-term future here. That's a major life goal for a lot of people.
Okay, so the appeal is huge, the numbers are massive, motivations are clear. But here comes the reality check. The part the legal team's material really drives home. This is an incredibly competitive landscape. Demand just blows supply out of the water. Let's really unpack the numbers from the most recent cycle, FY 2025, to understand just how tough this is.
Yeah, this is where the rubber meets the road, and the numbers tell a pretty stark story of intense competition. So Congress sets an annual limit, a cap, on new H-1B visas each fiscal year. For FY 2025, that cap was 85,000 visas total. That 85,000 is split. 65,000 for the regular cap, and then an extra 20,000 set aside specifically for people who've earned a U.S. master's degree or higher. That's the advanced degree exemption.
85,000 visas available, and the number of people trying to get one.
Well, the legal team's data shows that for the FY 2025 lottery cycle, USCIS received, get this, a staggering 470,582 electronic registrations. Now, a really key point here and a big change for FY 2025 was the new beneficiary-centric lottery system. See, in previous years, if one person had legitimate job offers from, say, 3 different employers, each employer could submit a registration for them. That person could potentially get 3 entries in the lottery. For FY 2025, that changed. Doesn't matter how many employers register you, you as an individual only get 1 entry in the lottery pool.
Ah, okay. So the 470,582 is the number of employer registrations, but the actual number of unique people entered in the lottery was different, less than that.
Correct. The legal team's breakdown confirms it. Those 470,582 registrations ultimately corresponded to 114,017 unique individuals who were selected in the lottery for FY 2025. So yeah, almost 500,000 registrations were submitted, but only about 114,000 people were actually selected to move forward and file a full petition.
But wait, 114,017 selected is still higher than the 85,000 visas available. Why did they select more?
Yeah, that's standard practice for USCIS. They always select more registrations than available visas because they anticipate that, not every selected registration will actually result in a filed petition. Maybe the job offer falls through, or the professional accepts a different offer, or maybe the petition, once filed, isn't approved, so they factor in that attrition. But the critical figure the legal team really emphasizes is the selection rate for the individuals in the lottery. With 114,017 unique people selected from a pool of registrants that, while less than 470K, was still much, much larger, the probability of your registration being selected was.
Pretty low.
Exactly. The legal team puts the selection rate for unique beneficiaries in the FY 2025 lottery at approximately 24%, just under 1 in 4. And this was a dramatic drop from the previous year, FY 2024, when the selection rate was 38.6%, almost 40%.
Wow. And the legal team says that big drop is directly because of that beneficiary-centric system change.
Yes, that's the key insight from their analysis. By taking away the possibility of multiple entries for one person, the system essentially shrank the total number of effective lottery entries relative to the number of people trying to get selected. Even though employers still submitted a huge number of registrations, the pool of unique individuals competing was smaller than it would have felt under the old system, where one person could have multiple tickets. This directly led to a lower chance of selection for any single individual.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Wow, 24%, 1 in 4. That really drives home the point about fierce competition. So what does that low probability mean for a graduate professional who's pinning their hopes on getting an H-1B?
Well, the main takeaway, as the legal team highlights, is the absolute necessity of having a solid strategic plan. You can't just cross your fingers and hope for luck with those odds. It's just too risky. It means professionals need to be thinking several steps ahead, exploring all potential eligible avenues, understanding that just getting a job offer from an employer willing to sponsor is only the first hurdle. Actually getting picked in that initial lottery, that's a major, unpredictable challenge. And it also really backs up the legal team's point about proactively looking into alternatives, like that E-2 visa we mentioned, especially if the H-1B lottery doesn't pan out on the first try.
Okay, that gives us a very clear, maybe a bit sobering picture of the demand and the competitive reality. Let's zoom back in now and define exactly what this H-1B visa is, according to the legal team's material. Back to basics. Lay that foundation.
Right. The core definition is pretty straightforward. The H-1B is a non-immigrant work visa. Its specific purpose is to let U.S. employers hire foreign professionals for jobs classified as specialty occupations. Now, that term specialty occupation is fundamental. It means the job itself requires theoretical and practical application of a body of highly specialized knowledge. And crucially, it requires at least a bachelor's degree, or its equivalent, in that specific specialty field as a standard minimum requirement for entry into the position.
So it's not just about the person having a degree. The job has to be one that inherently needs that specialized degree. And the legal team gives examples, right?
Yes, they reiterate those common fields we talked about earlier because they're classic examples where the job duties clearly fit the definition. Think software engineering usually needs a computer science degree. Medical research demands advanced degrees in biology, chemistry, etc. Roles in finance needing degrees in economics, finance, quantitative analysis. These are all roles where that specialized education is the norm. The whole visa process is managed by U.S. Citizenship and Immigration Services, USCIS, and the legal team rightly calls it a key, if competitive, pathway for skilled professionals into the U.S. workforce.
Got it. Work visa, tied to specific professional roles needing specialized knowledge and a degree. What are the absolute must-know features of the visa process itself, based on the legal team's breakdown? Let's tick through the key requirements.
Okay, the legal team outlines several critical features you absolutely must understand. First, again, is that specialty occupation requirement. You need a job offer for a position that USCIS agrees requires specialized knowledge and a relevant degree. The legal team's example, like a data scientist at Meta, fits perfectly. The duties complex data analysis, model building, algorithms clearly demand advanced knowledge.
So the job description itself is just as critical as the candidate's qualifications, maybe even more so initially.
Hugely important. Second fundamental feature, employer sponsorship. Cannot stress this enough. The H-1B process is started and driven by the U.S. employer. An individual cannot just apply for this visa on their own. The employer has to be willing to sponsor them, which means committing to navigating the process and, importantly, paying for it.
And part of that employer sponsorship involves the labor condition application, the LCA that you mentioned briefly.
Yes, and it's a vital first step even before the main H-1B petition. The employer must file a labor condition application, or LCA, with the Department of Labor, DOL, and get it certified. Now, part 2 of our series will dive much deeper into the LCA, but its basic purpose, as the legal team outlines, is to protect U.S. workers. On the LCA, the employer essentially promises to pay the H-1B worker the required wage, which is usually the higher of what they pay similar U.S. workers, or the local prevailing wage for that job, and provide working conditions that won't hurt U.S. workers.
Okay, job qualifies, employer sponsors, employer gets the LCA certified. What about the professional's own qualifications? The legal team spells out the education needed.
Right. The baseline requirement is a bachelor's degree, or its equivalent, in a field directly related to the specialty occupation. Now, the legal team clarifies the equivalent experience part. Typically, USCIS considers 3 years of relevant work experience to be equivalent to 1 year of missing bachelor's degree education. So if a job needs a 4-year degree, someone with, say, an unrelated degree might need 12 years of relevant, progressive work experience to qualify based on equivalence. But honestly, having the required degree is usually the cleaner, more straightforward way.
And then there's that critical advantage we talked about for folks with advanced U.S. degrees.
Absolutely. The legal team highlights the advanced degree exemption again. If you've earned a master's degree or a PhD from a U.S. university or college, you're eligible for that separate pool of 20,000 visas. These are allocated before the main regular cap lottery. This gives those graduates a significantly better statistical shot at getting selected compared to those with just a bachelor's or maybe a foreign master's degree.
How long can someone actually work and stay in the U.S. on an H-1B? Is it indefinite?
Oh, no, it's definitely a temporary visa with a set duration. The initial approval is typically for 3 years. Then it can be extended for another 3 years. So the standard maximum stay is 6 years total. However, the legal team notes a crucial exception. If the H-1B holder has started the process of applying for lawful permanent residency, a green card, they might be eligible for extensions beyond that 6-year limit until their green card case is decided. This is what makes it such a key pathway to potentially staying long-term.
And we keep coming back to that $85,000 annual cap. But the legal team's material points out some employers aren't subject to this cap at all. That sounds like a huge advantage. Who are these cap-exempt employers?
This is a really important detail for anyone job searching for H-1B sponsorship. Certain types of employers are exempt from the annual cap. This means they can file H-1B petitions anytime during the year for qualifying jobs, and these petitions don't count against that $85,000 limit. The legal team specifically lists institutions of higher education universities, colleges like Stanford, for example, also nonprofit research organizations that are connected to or affiliated with universities, and governmental research organizations like the National Institutes of Health, NIH. Working for one of these completely bypasses the whole lottery uncertainty and those low odds.
Wow, yeah, that significantly changes the game if you can land a job with one of those. What about the money side for the individual professional? Do they have to pay the fees for this visa?
This is another key point the legal team clarifies. While there are definitely significant costs involved USCIS filing fees, legal costs for attorneys, these are the employer's responsibility. The USCIS filing fees alone can range from $460 up to $2,805, depending on things like the employer's size and if it's the first H-1B, plus legal fees. But crucially, the legal team states the professional beneficiary of the worker typically does not pay these costs directly. It's an employer-sponsored visa, so the financial burden of the petition process falls on the sponsoring company or organization.
That's definitely a big relief for candidates knowing those fees aren't coming out of their pocket. What about family? If someone gets an H-1B, can their spouse or kids come too?
Yes. The H-1B does include provisions for dependents. Spouses and any unmarried children under 21 are generally eligible to apply for H-4 visas. The H-4 allows them to live in the U.S. with the H-1B holder. And a particularly important detail the legal team points out is that some H-4 spouses can actually apply for work authorization. This is a huge benefit for families, allowing potentially 2 incomes and letting the spouse pursue their own career here, though getting that work authorization usually depends on the H-1B holder reaching a certain stage in the green card process.
Okay, so to recap, H-1B is temporary, for skilled jobs, needs employer sponsorship, and a certified LCA based on a relevant degree or equivalent experience. It has time limits but can lead to a green card, faces an annual cap unless the employer is exempt, the employer pays the fees, and family can usually join, with some spouses potentially able to work. It's a really solid overview. Now let's move to that crucial first step, the one that decides if you even get a shot at filing the full petition, the electronic registration process. The legal team calls this streamlining the selection. How does it actually work? Why did they bring it in?
Right, the electronic registration. It was a pretty recent change, started by USCIS back in 2020. And the legal team explains its main purpose was exactly that, to streamline the selection for those cap subject H-1Bs. Before this system, employers had to prepare these huge, costly H-1B petition packages and mail them in during a short window, without even knowing if they'd make the cut before the cap was hit. It was kind of chaotic. The registration system simplifies that initial stage dramatically. Employers just submit basic info electronically to get the candidate into the lottery before they have to invest all the time and money for the full petition.
So it's like a pre-lottery step. Cheaper, faster.
Yeah.
How does an employer actually do the registration, and what's the typical timeline?
The process is all electronic and very time-bound. There's a specific annual registration period. The legal team notes it typically happens in early March. So for the upcoming FY 2026 cap, which will be decided in spring 2025, the registration window is expected to be around March 1st through March 20th, something like that. The exact dates get announced officially by USCIS, usually in February, on their website, uscis.gov. Employers use the online portal, my.uscis.gov, to submit each registration.
And what specific information do they need to submit for each candidate?
The legal team's material lists the essential details needed. You need the beneficiary's info, full name, date of birth, country of birth, passport info, and very important confirmation if they qualify for the U.S. Master's Cap exemption. You also need the employer's details. Company name, their employer identification number, EIN, that's the company tax ID, and the proposed job title and wage info. If an immigration attorney is helping out, their details go in too. It's relatively brief information compared to the full petition, but accuracy is absolutely critical.
There are just too many visas out there, and I don't know which one is right for us. We need to get the right advice.
Communication is everything, and I just need someone who will listen and guide me to the right visa type, and not make promises that they can't deliver.
There are so many documents. I need someone to walk me through each one. I can't afford to make any mistakes.
If I can just find a lawyer who understands my potential, I know America will be an excellent opportunity for me and my family.
Welcome to the law offices of Chris M. Ingram, and we are your immigration lawyers, and we will be with you every step of the way in your immigration journey.
At the law office of Chris M. Ingram, you get a free consultation so we can understand your needs.
We don't make promises we can't keep. Our success rate speaks for itself.
Join us and access your step-by-step video guides that answer every visa question.
Their platform is amazing. There are videos that instruct you on everything you have to do. It meant we were in control and we could do it in our own time.
They couldn't have been more helpful. They answered every question that I had, and it was easy to see they were the lawyers for me.
I couldn't believe it with my busy schedule. They always had time to talk to me and put me at ease. That's what I like about them.
So go on our website and get your free consultation now, and your new life is about to begin.
Ask me.
We did it! We did it!
We did it!
Oh my God, I got my visa! Yes, I did it!
And there's a small fee involved for each registration, right?
Yes, a non-refundable $10 fee per registration. The employer pays this for each candidate they register. It's minimal compared to the full petition fees, reflecting that goal of making the initial step accessible.
Now, you mentioned that big change for FY 2025, the beneficiary-centric system. The legal team really highlighted its impact. Can you explain that again and how it affected those numbers we saw?
Yeah, this beneficiary-centric system is probably the most impactful recent update to the H-1B lottery. The legal team emphasizes that before FY 2025, if multiple employers wanted to sponsor the same person, each could submit a registration. Each registration got its own separate entry into the lottery. So one person could effectively have multiple tickets in the draw, boosting their statistical chances. The beneficiary-centric system changed that completely. For FY 2025 and going forward, each unique individual gets only one lottery entry, no matter how many employers submit registrations for them.
So the system focuses on the person, not the number of companies trying to hire them for the lottery draw itself.
Exactly. The lottery pool is now based on unique individuals registered, not the total count of employer registrations. That's precisely why, for FY 2025, we saw that huge number, 470,582 registrations, but only 114,017 unique beneficiaries were actually selected. Even though nearly 500,000 registrations went in, they represented a much smaller pool of actual people because of that one person, one entry rule. And that's the direct reason for the significant drop in the individual selection rate, down to that 24% figure. The aim was to make the odds more equitable for each person in the pool.
That makes the impact much clearer, definitely. Okay, so registrations are submitted electronically in March. How does the actual lottery happen once that window closes? What's the legal team's description of that process?
The legal team outlines a two-stage lottery process. It's designed specifically to give those U.S. advanced degree holders their advantage. So, the first lottery draw is conducted just for the 20,000 visas reserved for individuals with a U.S. master's degree or higher. If the number of eligible registrations in this group is more than 20,000, which it always is, by a lot, USCIS randomly selects from this group until that 20,000 cap is filled.
And what about the U.S. master's degree holders who don't get picked in that first round? Are they just out of luck?
No, this is where the second stage comes in, giving them that second chance. The legal team explains that any registrations for U.S. advanced degree holders that weren't selected in that first lottery are then automatically rolled into the pool for the second lottery. That's the regular cap lottery, for the remaining 65,000 visas. This lottery is conducted among all the remaining registrations. That includes people with bachelor's degrees, U.S. or foreign equivalent, foreign master's degrees, and those U.S. advanced degree folks who didn't get picked in round one.
So having a U.S. graduate degree basically gives you 2 bites at the apple. First in the exclusive pool, and if you miss out there, you get thrown into the main pool for another chance.
That's the clear advantage the legal team's description highlights. It significantly boosts the odds for people who've invested in getting that U.S. graduate degree. USCIS usually announces the lottery results pretty quickly after the registration closes, typically by March 31st.
And if an employer's registration is selected in either lottery, what's the immediate next step for them?
Right. If a registration gets selected, the employer who submitted that specific one gets notified by USCIS through the online system. That notification basically gives them the green light to proceed with filing the full, detailed H-1B petition. They're given a specific filing window, usually 90 days from the selection date, to prepare and submit the complete package. That means Form I-129, petition for a non-immigrant worker, plus all the supporting documents, the certified LCA we talked about, proof of the beneficiary's qualifications, details about the job, the employer, everything.
This electronic registration sounds, relatively simple compared to the full petition. But what are the critical things that professionals and employers really need to watch out for? The legal team lists some key considerations, potential pitfalls.
Yeah, and the legal team's advice here is absolutely crucial for avoiding problems down the line. One critical factor, accuracy, absolute accuracy. They stress that errors in the registration, even things that seem minor, like a typo in a passport number, misspelling a name, wrong date of birth, or incorrectly claiming master's cap eligibility can be fatal. Even if that registration gets selected in the lottery, if those initial details were wrong, it can lead to the full H-1B petition being denied later because things don't match up or the person wasn't actually eligible as registered. This is where the legal team really emphasizes the value of having experienced legal counsel double or triple check everything before hitting submit.
Wow, so getting selected is definitely not the finish line. Mistakes made way back at the registration stage can still sink the whole thing later. What about that point on multiple employers registering one person under the new system? The legal team said it can still boost chances somehow. Can you elaborate on that nuance?
Yeah, this is a subtle but important point the legal team clarifies. While the beneficiary-centric system means you only get one entry in the lottery pool as an individual, having multiple legitimate employers who are willing and able to register you does still increase your chance that a registration submitted for you will be selected. Think of it like this. You have valid job offers from Company A and Company B, both register you. You still only get one ticket in the lottery under your name. However, if that single ticket is drawn, either Company A or Company B could then file the full H-1B petition for you. So it doesn't get you more lottery entries, but it increases the likelihood that if your entry is selected, you have a confirmed sponsor ready to move forward. The legal team is very clear, though. This only applies to genuine job offers. Submitting registrations from companies you don't actually intend to work for is a big no-no, serious consequences.
That clarification really helps. It's about diversifying your potential sponsorship options if you get selected, not about getting more chances in the lottery itself. What about timing? How critical is that?
Timing is incredibly critical. The legal team really advises on this. That registration window in early March, it's short and it's firm. This means potential H-1B candidates usually need to have secured their job offer and gotten the employer's commitment to sponsor well before that. Typically by January, maybe early February at the latest. Why? Because it gives the employer and their legal team enough time to gather all the info, verify everything for accuracy, and prepare the registration submission before that short March window opens and slams shut. Miss it, and you wait a whole year for the next cycle.
And finally, the legal team is pretty upfront about the challenges built into this whole process.
Yes, and it's important to be realistic. That low selection rate, probably the biggest hurdle. 24% for individuals in FY 2025 means, sadly, most hopeful applicants won't get selected in any given year. There's also the challenge of employer hesitancy. Even though the employer pays the fees, it's still a cost, it's an administrative burden. And the uncertainty of the lottery outcome can make some employers, especially smaller companies or startups, a bit reluctant to commit. And from the professional side, there's a big element of reliance. Your ability to get an H-1B depends entirely on a U.S. employer willing to sponsor you, and then successfully navigating the whole process accurately and on time. It really requires clear communication, trust between the candidate and the employer.
That provides an incredibly detailed look at the H-1B itself and that critical first step, the electronic registration covering eligibility, cost, timeline, challenges. To really see how this plays out, the legal team provides a scenario. A software engineer named Priya. Can you tell us about her background, her journey as described in the material?
Certainly. Yeah, the scenario introduces Priya. She's 26, from Bangalore, India. Her interest in tech started early coding games as a teen, influenced by her dad, an engineer with some ties to Silicon Valley. She pursued that passion, came to the U.S. for grad school, got a master's in computer science from UC Berkeley. Now, her field, comp sci, is a designated STEM field: science, technology, engineering, math, and that's crucial for her story. She's particularly passionate about AI, very active in hackathons, tech community stuff.
And where's she working now? And on what immigration status?
According to the legal team scenario, Priya is currently working on optional practical training, OPT, at a tech startup in Seattle. OPT is that temporary work authorization students often get after graduating, letting them work in their field. Her initial OPT is for 12 months. However, because her degree is STEM, the legal team highlights she's eligible for a 24-month STEM OPT extension. That gives her a total potential work authorization of 36 months, 3 years after graduation. That's a significant window.
And she's clearly proving her worth at the startup.
Oh yeah, the legal team's scenario emphasizes this. Her work on machine learning algorithms directly boosted their sales by 20%. That's a tangible impact, clearly showing her specialized skills and value.
Okay, so she's a high-value employee on a status, OPT, that gives her time to work and prove herself, and she's eligible for that long extension. But what hurdles did she face with H-1B sponsorship, according to this scenario?
Well, the legal team's story reflects a really common challenge. Even though the startup recognized her value, praised her work, they initially hesitated when it came to committing to the H-1B sponsorship. The scenario specifically mentions their concern about the costs involved. That's a very real barrier, especially for smaller companies, startups maybe with tighter budgets or less experience with the whole immigration process.
So how did Priya handle that employer hesitation?
This is where her OPT status became strategically vital, as the legal team illustrates. Her initial 12 months, plus knowing she had the potential for that 24-month extension, it basically bought her crucial time. It let her keep working legally, keep demonstrating how indispensable she was. She proactively used this time, took the lead on a high-stakes project, further showcasing her skills, making it, harder for them to imagine losing her.
Still, even while proving her value, those low H-1B lottery odds must have been causing some serious anxiety.
Absolutely. The scenario captures that real stress. The legal team mentions the low lottery rate, that 24% chance haunted her. It fueled genuine worry about potentially having to leave the U.S., go back to India if she wasn't selected. That uncertainty is a huge emotional weight for many people in her shoes.
So what proactive steps did she take? Did she just wait and hope the startup would come around? Or did she try to improve her chances, explore other options based on the legal team's story?
No, she didn't just wait. The legal team highlights her strategic networking as key. She actively joined online communities like LinkedIn AI groups, started connecting with engineers at larger companies, places potentially more comfortable with H-1B sponsorship like Microsoft. And a pivotal moment came at a virtual hackathon. She demonstrated a predictive model she'd developed, and it got significant praise from Microsoft engineers who saw it. That interaction led directly to her getting a job offer from Microsoft.
Wow. So by leveraging her skills, networking actively while still on OPT, she landed a second, possibly stronger, job offer from a major company known for sponsoring H-1Bs. How did she handle the electronic registration then? With offers from both the startup and Microsoft, what does the legal team's scenario say?
This is where her strategy and the beneficiary-centric system came together nicely for her, as described by the legal team. With 2 legitimate job offers, Priya made sure both employers, the startup she was at, and Microsoft submitted electronic registrations for her during that March window. She worked closely with her attorney to make sure all the details on both registrations were accurate, consistent. The key, again, under the new system. Even with 2 registrations submitted, she only got 1 entry in the lottery pool as an individual. But having 2 potential sponsors lined up meant that if her single lottery entry was selected, either the startup or Microsoft could proceed with filing the full H-1B petition. It maximized her chances of having a sponsor ready to go if she won the lottery.
That perfectly illustrates that nuance we talked about, the value of multiple legitimate offers under the new system. So what was the final outcome for Priya in this story?
The legal team scenario gives Priya a positive ending. She was selected in the FY 2026 lottery, and notably, she was selected in the advanced degree lottery first. That highlights the real benefit of having earned that U.S. master's degree. It gave her that first shot in the smaller, slightly less competitive pool. And reinforcing the value she'd proven, it was her original company, the startup, that ultimately moved forward and filed the big Form I-129 petition for her once her registration was selected.
So despite their initial worries about cost, the startup stepped up once she was selected, securing her future there. That's great.
Exactly. The scenario wraps up with Priya successfully getting her H-1B visa effective October 2026. The legal team adds a nice touch she celebrated with her family back in India over video call. That moment where the dream of building her career here became real.
That's a fantastic story. Really brings the whole abstract process and the strategies to life. Based on Priya's experience and everything else we've covered, what's the key takeaway here, according to the legal team?
The legal team explicitly states the main lesson. Using your STEM OPT period effectively, strategically, and securing multiple legitimate job offers from employers willing to register you. These are powerful strategies. They can significantly maximize your chances in the H-1B process. STEM OPT gives you that essential time to gain U.S. work experience, build relationships, prove your value, and having multiple employers willing to register you, even under the beneficiary-centric system, increases the statistical probability that at least one registration linked to your name will get picked in that super competitive lottery.
This has been an incredibly insightful deep dive, understanding the H-1B opportunity, the visa basics, that critical electronic registration step, all thanks to the detailed material from the legal team. We've covered a lot today. But like you said at the start, this is just part 1 of 4. The journey definitely doesn't end with the lottery selection. What can listeners look forward to in part 2?
Right. In part 2, we'll keep building on this foundation, again drawing from the legal team's material, to explore other really crucial parts of the H-1B process. We'll dive much deeper into the labor condition application, the LCA, that we introduced today, understanding the specifics of the LCA, its purpose, what the employer has to attest to. That's vital. We'll also take a more detailed look at optional practical training, OPT, the status Priya was on.
Yeah, and as we saw with Priya, OPT is often that bridge status, right? The what graduate professionals are on right after finishing school, using that time to work and find sponsorship before the H-1B clock really starts ticking. So understanding OPT is essential for many.
Exactly. Part 2 will explain the mechanics, the importance of OPT in more depth, all based on the legal team's info. And the legal team's preview for Part 2 also introduces a new scenario. We'll meet Aisha, a data scientist from Nigeria. Her story will highlight different challenges, different strategies compared to Priya's, offering another valuable perspective on navigating this path.
Okay, before we wrap up this part of our deep dive, let's leave you, our listener, with something to think about based on everything the legal team shared today. We've seen the incredible demand, the really low selection rate in the H-1B lottery, just 24% for individuals recently. Given that intense competition just to get selected, just to get the chance to apply, how might understanding the specific criteria USCIS uses to evaluate the full petition after selection, the things that make a case strong, beyond just meeting the minimums, How might knowing that influence your career choices, the skills you develop, the types of jobs you go for even before you enter the registration lottery?
That's a powerful question. Knowing what makes a winning petition, not just a winning registration, could definitely shape decisions. Which job offers to really target, how to maybe tailor your experience. And kind of expanding on that, thinking about the alternative the legal team mentioned, like the E-2 visa, how might actively exploring multiple immigration pathways early on, instead of putting all your eggs in the H-1B lottery basket, change your whole strategy? Especially if your main goal is simply a stable long-term career in the U.S., regardless of whether you win that specific lottery. Definitely something to mull over as you chart your course.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Once again, we would like to thank attorney Chris Ingram and his team for researching and preparing this material for our presentation today. That you're doing an awesome job. Please leave us a comment if you can, as it really means a lot to all the staff. If you'd like to book a free consultation, please visit www.breakthroughusa.com. See you next time on Let's Talk U.S. Immigration. Bye for now.